He's a voting member, yes. He's anyway, brother.
All rise for the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Attendance.
Attendance, please.
Yes, sir. Registrar Pereira.
Present.
Turn on your mic.
Myself, William Maloney, present. City Clerk. Attorney Body. Present. And Chairman Petrakis.
Present.
All present.
This evening's agenda, Thursday, January 26th. First is the 2016 election calendar submitted for the board's approval. Second is Rivera Recall 1, objection hearing, Recall 1 petitions, and Recall 1 further proceedings to be scheduled, followed by adjournment. So, City Clerk, the calendar.
Thank you, Mr. Chairman. I present to the board normal course of business, 2016 election calendar submitted for your consideration, containing the dates through the election in November 2016. And I present that as a form of motion to approve the calendar as presented.
Motion to approve it.
Seconded by Councilor Pereira. All in favor, say aye.
Aye.
Attorney Body not a voting member as to that issue. 3-0. Thank you.
Next, we'll move on to Rivera Recall 1. For that, I will give the floor to Attorney Bodie. Is there anything you want to say to address?
No, I think that we're going to be following the CMRs as we did in the objection phase to the affidavits and with respect to the need to. Evidence needs to be provided, and the weight of the evidence has to be that upon which a person would make a serious decision. So that's the standard for review. I think that's all that we need to say.
If I may, Mr. Chairman.
Please.
Attorney Body, just a quick question as to procedurally, shall we proceed in any particular order? Petitioner first, mayor's council second, at your suggestion.
Well, we don't have anyone here. We don't have anyone here, I don't think, from the petitioners yet. So that being the case, I guess we proceed with the elected officials' objections.
Councilor Zavi?
Thank you, Commissioners. Good evening. Good evening, Mr. Chair. First of all, by way of explanation of what we plan or intend, I'd like to let the board know what our intentions are with respect to our objections that were specifically filed. That is, with respect to our objections, we do have present a handwriting expert who we expect will testify as to the legitimacy of a certain, or his opinion as to the legitimacy of a certain number of signatures that were certified by this board. We also anticipate having live witnesses who will testify that they did not sign the petitions with the name that was reflected on the petitions submitted. Prior to that, however, I know that Attorney Fair is not here, but I do know that on behalf of the group, he filed some specific objections, and I think that before we go any further with respect to that, I think that there's an argument that I think that needs to be made before this board. And over the course of the past many months, there's been a debate about what types of objections were permissible before this board as to signatures and when they were permissible. And there was a debate whether or not objections to signatures were allowable at an affidavit stage or not. And that has been litigated and continues to be litigated. However, there has been no dispute whatsoever that at this stage, there are several provisions in Massachusetts state law that apply. Specifically, Mass General Laws, chapters 48, section 43, section 38, Mass General Laws, chapter 53, section 7, and Mass General Laws, chapter 55B, section 7. Not only has it never been up for debate, but the city itself, in a case in 1995 and 96, the Stapleton versus 9 case that was heard in Superior Court, the city conceded as much and agreed that your board had adopted certain articles and bylaws on how to deal with objections, and you were to handle them the same way the State Ballot Law Commission handles objections. And those are the CMRs that I believe Mr. Body referred to in his opening statements. Now, in 1976, in a Supreme Judicial Court case, McCarthy versus Secretary of the Commonwealth, the Supreme Judicial Court of this state made very clear what local board of registrars are allowed and not allowed with respect to verifications or certifications of signatures, and what the State Ballot Law Commission is allowed to do. And McCarthy was quite clear that once you have certified a certain number of names and have refused to certify others, there is absolutely no provision and no authority for you to put names back on certification. There is a remedy for that, and that remedy is an action in the Superior Court. The only thing that this board can do is take names off of the certified list for reasons of fraud or forgery. And that's it. Other than that, this board can do nothing other than what it's already done. And McCarthy is crystal clear as to that. There has been no other authoritative case, no other appellate court case or Massachusetts Supreme Judicial Court case to suggest otherwise. And to the extent that Mayor Rivera has submitted objections to this board that do not address issues of forgery or fraud, they are done so for the purpose of preserving the record and the ability to then address that at a higher court. But again, there is no case to suggest otherwise. There is no authoritative case that allows you to do anything more than you've already done, except hear objections as to forgery or fraud and determine whether that's the case or not. And the language in the case is quite clear, and I have a copy of that for all of you.
Please.
Do you have a copy? There you go.
Oh, McCarthy.
Those people that are here already? Okay, perfect. I'll get that from you in a second. Thank you. So with that, I asked the board to make a determination or a ruling with respect to that, and then if the board is still so inclined to hear our objections, we'd be prepared to put on our expert.
I apologize for coming a few minutes late. Good evening to everybody. I caught a piece of what my brother Salim Tibet is addressing, which is the McCarthy case. The problem with the McCarthy case is that the McCarthy case refers back to Mass General Law 55. Let me see.
Bravo.
Give me 1 second. I'm sorry, 53, Section 7. And it deals with nominations, papers, et cetera. There is nothing in 53, Section 7 that mandates that you have to follow McCarthy. There is a case that's a 1984 case. It's entitled 4,568 Registered Voters of Worcester. It's a Supreme Court case. It's a 2-page decision. And in that position, in that paper, they cite, this is their words, "We noted that the legislature did not intend the local registrars be free to reject signatures without giving reasons for such rejections. There is a burden that they place under McCarthy, and they require you to hear, as a judge will hear, all of the objections." So my recommendation is, and I have this case for counsel, and if I may approach. Go ahead.
As far as the case presented by Mr. Farah, I agree. This board cannot reject signatures unless there are reasons for doing it as outlined in McCarthy. And that's precisely the reason why the city clerk's office marks down the reason why they were not certified. So that has been done, and the reasons have been presented, and this board accepted the certification of a certain number of signatures and rejected others, and the recourse for them is to go to court and to have all of those signatures which they claim should have been allowed, now that the board has already determined with reasons for it that they were not allowable, reviewed in court. Thank you.
Very simple question for the board is a question about the methodology under which people for the election division accepted or rejected signatures. What authority did you use? And it's a general question to whomever on the board would like to answer it. What was the authority that they chose, that they used in asserting whether or not to accept or reject a signature? Is there a rule book? Is there a statute? Is there a code? And I think that this audience, including the mayor, deserves the right to know what the methodology, what the procedure, what the process was, and what the authority was that they used. And I'll direct that to Richard.
Excuse me, City Attorney, I don't know, he's not been sworn in, he's not on the stand, this is not part of the, just as a matter of procedure, I would suggest to...
First and foremost, any questions you may have to be directed to the chair, just as a matter of formality and procedure. I'll just leave it at that for the moment.
Well,
I think
on top
it's-
of that, I would suggest that the witness has not been sworn. It's not this portion of the case for Mr. Farah, for the petitioners. He's not presenting any evidence. He's not authorized to present any evidence at this point. He may at some point, but this is, I think he's jumping the gun.
All right, so you're suggesting that you want to get past this idea
I'm
whether
not suggesting
McCarthy
anything.
prevails?
I don't have the witness before the board. I
Okay.
don't see one.
Well, are we addressing McCarthy, or are we proceeding with the objections?
Last I understood, we're proceeding with objections from the mayor's side.
Attorney Tibbet has raised the issue. Attorney Tibbet has raised the issue that, under McCarthy, the board has no jurisdiction to hear objections by the petitioners to the non-certification of names that they feel should have been certified. I think this board needs to take up that issue before anything further. What Attorney Tibbet has said is this: if in fact you have no authority to hear objections from the petitioners, then by virtue of the certification, the recall fails. And so there's no need for him to proceed on any objections. We can close the meeting and we can go home, and the redress, if needed, of any issues with respect to the certification process would be conducted in the Superior Court. That, I think, I don't mean to put words in your mouth, but I think in substance, that's what you're suggesting. And go ahead,
If I just may, the only thing is
I'll let you speak for yourself for a
Thank you.
change.
I do not suggest that the petitioners do not have a right to object, but they do not have a right to object for purposes of putting names back on the petition that's already been certified. So I
So
just,
then
you
what
made
would,
that,
so then what would they be objecting to if that's not
well,
their,
I just want to be clear on the
they would object that
record.
names that they submitted should be taken off also?
Mr. Attorney Body, I know you're being cute, and I get it, but I just want to specify that. I'm not suggesting that petitioners have no rights, and they certainly have rights before the Superior Court, but I just wanted to clarify that small point.
For my own clarification, McCarthy is saying that we cannot put signatures back on. McCarthy isn't saying that we can't hear the objections of the petitioners.
If you read McCarthy all the way through, McCarthy says that essentially, if the Board of Registrars has certified the names, no one can put the names back on. What happened in McCarthy was that the courts have the authority to order the Secretary of the Commonwealth to place names on the ballot if they feel that the certification process was flawed. In other words, if they feel that there was some defect in it that warrants that means a person would have been certified. But what McCarthy makes clear, I think, is that the courts can't order boards of registrars to add names back in. So what the appeal is to the to the Superior Court isn't one to certify names that weren't certified initially, but to conduct a review of the certification process, and if the certification process was flawed in such a way that the standard would have been met, in other words, 15% of the registered voters had signed the petition, then it would order the City Council to order an election.
I also believe, in addition, that McCarthy, which is a 1977 case, references General Law 53, Section 7. General Law 53, Section 7 in 1977 is a little bit different than General Law 53, Section 7 in 2016. And there is nothing in 53-7, the 2016 edition, which requires you not to review the process of the election division and not to hear objections. It's
Hearing
kind of
obje-
old law reciting old statute.
Hearing
That's my point.
objections and changing the outcome are very different. Right, so you're saying we can hear objections, and I don't disagree that we can hear the objections of the petitioners, but McCarthy's saying that we can't put names back on.
It's a 1977 case that says, if you look
Supreme
at...
Court.
Supreme Court case in 1977, in 1977, if you look at the 1977 version of General Law 53, Section 7, that may have been the law then. That is not General Law, Chapter 53, Section 7 today. There's no restriction in 53, Section 7 that prohibits you from hearing these objections. That's my point. The law has changed. McCarthy's printing is still the same, but 53, Section 7 has changed since 1977. And if you take a look at it, you will see nothing in 53, Section 7, which puts a prohibition on you to recertifying names should you find that somebody acted inappropriately. Or inaccurately is a better way, I'm sorry.
The point is, I don't think that either version provides for that. I would suggest that the later version is to conform with McCarthy. I don't care if it's 1976 or 77, or if it's 1876 or 77. That is good law. It hasn't been altered in any way, and it is the precedent in the Commonwealth of Massachusetts, whether it was 30 years ago or not. That's the principles by which we go by.
What did change in the revision?
There is no restriction in the present Chapter 53, Section 7 is silent, as far as I can tell, on whether or not you can overrule or recertify names that are presented to you by objection.
Well, I just want you to take note that the McCarthy case is a case that involved the State Ballot Law Commission, not a local board of registrars. And that may or may not create a difference. But in that particular case, the ruling was that the State Ballot Law Commission has no jurisdiction. And if you ask the Secretary of State's office, they will tell you exactly what Attorney Tibbetts says, that that is still good law, that the State Ballot Law Commission does not have any jurisdiction to certify names which were not originally certified. However, one of the problems that we have, and something that you'll have to determine as a board, is that with respect to the conduct of review of objections before a local board of registrars, there is very, very little guidance. The best guidance we have is probably a case that started right here in our own community, Stapleton versus Charles Nyan, the former city clerk, where there were objection hearings, and the results of the hearings were appealed to the Superior Court. So what one side is arguing is that by analogy, the restriction or prohibition that the State Ballot Law Commission has also should apply in similar proceedings such as these before this board. And I would not be doing my due diligence if I didn't call the board's attention to the fact that there are at least two cases, and I know Attorney Tibbetts waiting for me to pronounce this so he can rebut it, but there are at least two recent cases where local boards of registrars have reviewed objections filed by both the petitioners and the elected officials, and that is Scanlon versus McHugh, which is a 1995 case, and the other one is, I think it's Flanagan, it is Flanagan versus Camara, which is a Fall River case from last year. The Board of Registrars in those jurisdictions entertained both sets of objections and made rulings, and then subsequent to that, it was appealed to court.
Are you familiar with the outcome of the appeal?
The appeal was not an appeal of that issue, whether the board, nobody questioned in those cases before the court whether the board had authority. They were appealed on other issues. So unfortunately, the cases don't treat that issue, but the issue is mentioned in the fact pattern so that you can see that the local board of registrars in both cases entertained multiple objections from each side.
If I may, so what Mr. Body is saying that neither one of those two cases have actually stood for the proposition which he has suggested. Not to mention that they're Superior Court cases which have no precedential value whatsoever. And if I may, with respect to Mr. Body making a distinction with respect to the Ballot Law Commission and local boards, McCarthy, two things. First of all, this city has already conceded that they've adopted the rules and regulations of the State Ballot Law Commission in your own bylaws. So I think that argument, quite frankly, is moot. But more specifically, the McCarthy case does address local boards. It addresses the State Ballot Law Commission, and then right after it, addresses the issue of local board of registrars and says the exact same thing.
Why don't
And
you
I
point
could
that
cite,
out? Why
and I
don't you
could
point
cite
that
the
out to us?
page to, is 678.
678?
Sure. And I can read it to you. The local registrars are given by General Laws, Chapter 53-7, a single discrete function to perform in the process of nomination by petition, that of comparing petitions submitted to them with the official list of registered voters and certifying those signatures, which are the signatures of registered voters of the municipality. They have that single function to perform, and once it is performed, they have no continuing duty.
But that's because, is it not, that this is for a state election? So the local Board of Registrars has no continuing duty in a state election because any review isn't conducted by the local Board of Registrars in a state election. It's conducted by the State Ballot Law Commission.
No, while that's true, it still applies to local boards and certification
What
locally.
that quote said, with all due respect, is that in the instance of a nomination to the ballot, where the nomination is done on a statewide basis, once the local board of registrars conducts their business, their role is over, and then it's up to the State Ballot Law Commission to hear objections, et cetera.
Well, while I agree with part of that, the State Ballot Law Commission is not entitled to hear any more objections than the local board as to whether signatures should be put back on the petition or
And I
not.
want to get away, a little bit, I want to get away from arguing Attorney Farrah's position, but I do want to say, because I think it bears saying, and I don't think anyone else will say it, that we have indeed adopted the regulations of the State Ballot Law Commission. But those regulations are about our internal procedures and how we conduct our business. So yes, we have done that. But that, I don't know, I'm not saying it does, I'm not saying it doesn't mean that we have adopted all of the liabilities, obligations, restrictions, and what have you, that the State Ballot Law Commission
Well,
has.
I will only state further, too, that although it's not authoritative, but you cited the case of Stapleton v. 9, in that case, the court, now, I don't know if this part was conceded by the city or not, but the court there indicated that 53-7, along with 43-8 and 55B, were the statutes that pertained to the certification of signatures. And if you
with
extrapolate
you.
that to
I
the
agree
State
with
Ballot Law Commission and the role of those commissioners, it's exactly the same thing I would suggest.
For nomination papers. 53, Chapter 53, Section 7 is entitled Nomination Papers, semicolon, Signatures, semicolon, Addresses, semicolon, Submission, semicolon, Deadlines, Correction Procedures, Certification, Checking, Special Elections. This reference in McCarthy, which is very definitive, is found nowhere in Chapter 53, Section 7. What the Supreme Court said in 1977, as my brother enumerated for you, is local registrars are given by General Law, Chapter 53, Section 7, and then it recites it. But there's nothing in 53, Section 7 that recites the present one, the 2016 version, as of this afternoon, that cites anything that's cited in McCarthy. I say it's inapplicable. Your obligation doesn't end with a certification by the Election Division. Your obligation is to review what the Election Division did, grant people who have redressed with the mayor and are trying to recall the mayor the right to be heard. My position.
If I may.
You know, I just might add, too,
Wait till John's done.
the issue isn't necessarily dispositive. It may be dispositive before this organ of government, the Board of Registrars. But depending upon what vote the board may make as to its ability to hear the objections brought by the petitioners as to non-certification of signatures that should have been certified, that can still be brought in the Superior Court. But that would be the obligation of the petitioners to do that. So,
If I may, Mr. Chair, through you, Mr. Tibby, if you wouldn't mind, and I guess this is somewhat addressed to Mr. Farah as well. I find it interesting to watch the right to due process shift from mayor's council to the petitioner in one fell swoop. But I guess it's, you know, I find it interesting in this sense only, and maybe it's more of a comment than it is a question, and maybe I should pose it as a question to council, to the mayor. You make a lot to do about due process before the Superior Court and the lack of it for failing to conduct, we'll say, review of objections where, quite frankly, I don't believe they belong anyway, but we'll find out on Wednesday next week whether it's the law of the land or just a whim.
You want me to answer?
I am almost sure, and maybe I'm asking this as opposed to commenting, that if we hand you the keys to the Corvette and say, yeah, we can't hear anything from the petitioners, you're right. McCarthy applies, go along your merry way, and off they go. And should this get filed in Superior Court on review for lack of due process by the board, understanding how courts work, and certainly judges worked in this case, I guarantee you, you're going to be right back here. I know that for certain.
I don't know if it was a comment or a question, but I'd like to
I guess
address
it's a
it,
little bit
okay?
of both. If
Because
you'd
I'd
like to
address
address,
it, because-
I'd like to be enlightened a little bit.
Sure,
How denying due process at this stage,
It's not a
even if
denial,
it's that.
it's not a denial of due
Wait,
process.
excuse me.
Yeah.
Can we just not speak over each other and have one of us speak at one time?
no, I was
And
finished.
not-
I was finished, that's all right.
Can we, let me repeat that. Can we just not speak over each other and let one of us speak at a time? Not only is it a problem for people's understanding, but it's disrespectful. I know neither of you intend disrespect. I know that Attorney Tabita has the utmost respect for the clerk and vice versa. But it's certainly a lot easier if we only talk one at a time.
Can I respond now? Thank you, Mr. Maloney. The mayor's position has been entirely and completely consistent. We objected at the affidavit stage on the basis of non-genuineness of signatures based on the possibility of forgery or fraud. Any objections we have made tonight are done on under the same grounds, which is consistent with McCarthy and consistent with all of the authoritative case law that we have and that we're aware of now. Chapter 53.7, by the way, I just want to address this real quickly, was changed and altered to address McCarthy. That's the only reason it was changed, and the change was because this Board of Registrars has an obligation to explain in its decision why a signature that may otherwise on its face have appeared valid to not be so. That is what the changes in that statute addresses, the demarcations on the signatures which indicate the person wasn't living at that address, so on and so forth. And I think that that's what this clerk's office has done since, at least since I've been around, and that's why the report that is read to you indicates how many were not, didn't found to be registered at a particular address, et cetera. But I would just suggest, I understand the due process question, but I would suggest that our position has been consistent from the get-go, our objections have been the same, and I think the court has laid out in McCarthy what the due process rights are of petitioners with respect to putting names back on the ballot, and that's to go to Superior Court. Thank you, Mr. Maloney.
No, I just was wondering at the fleeting due process, because it seems to disappear when it goes to the other side. Now, they are not entitled to be heard except in court when the court tells the board, quite frankly and directly, that, geez, you really better let both parties speak and conduct a hearing thoroughly. Because I can almost assure you, future members of the bench and the bench people, the bench judges who may hear this, will kind of look at it when they're looking at 3, 4, 5,000 signatures and asking, what's the board's decision on hearing the petitioners? And I say that rhetorically, not in any specific real-time sense, that if there is nothing for a court to grab a hold of, that the board had made a decision denying signatures, allowing signatures, reviewing signatures, then, as I think what I'm saying is what Attorney Barty said, what the heck are we doing here? Why don't we just pack up and you guys go off to Superior Court and good luck? Is that what you suggest?
If I said that, I did it in
Well,
much shorter fashion.
Much shorter.
Chapter 53, Section 7, let me count the paragraphs, 1, 2. I guess on my page 2, this is the current one, states, "The provision of this section shall apply to all cases where any statute, special act, or home rule charter requires the certification of a signature of a voter by the Board of Registrars of Voters." In the sentence or two above that, 53.7, the 2016 section says, "For the purposes of this section, a registered voter who is signing his name to a nomination paper inserts a middle name or an initial in, or omits a middle name or an initial form, his name as registered shall be deemed to have signed his name substantially as registered. If the registrars can reasonably determine from the form of the signature the identity of the duly registered voter, the name shall have been deemed to have been signed substantially as registered." I raised that point because I've taken the position that 53.7 is applicable, the terms of 53.7 presently are applicable to the determination by the Board of Registrars as to what constitutes a signature. I also take that position because, again, and this will be the last time I say it, give my word on it, there's nothing in 53.7 presently that limits your ability to review the work of the Election Division.
Briefly, Mr. Chair. And again, I like kind of talking in riddles about this. I really do believe that due process is not an orphan that goes from one side to the other and seeking a home. I think it goes to both sides. And I see nothing in McCarthy, having read it thoroughly. I see nothing in 53.7 myself, and nothing in 50. I mean, maybe I should put it in another way. I am looking for a case on point that says, in recall elections, this is what you do. And I haven't heard counsel from either side say that, or even our own counsel. And here's the form that you use. And this is exactly the process. And I think one thing the city attorney is telling us, all of us, is there is really no instruction. Because I know he is exhaustively, as you guys have, counsel to both sides, searched for that case. Because if you had it, you'd be standing here and going, yeah, here it is. This is it. So
Well,
I guess we're forging our way.
Well, Attorney Tibbet is saying that. He's saying, this is it, here it is. And he's asking you to adopt that.
Well, I
let me,
disagree with
you know,
him.
I guess, you know, it's not my hearing, and maybe I'm already speaking too much. I know that the conversation is over here, but, you know, I'm trying to reconcile a little bit with what I see as the Board of Registrars' obligation is in these circumstances. And after McCarthy, the CMR was composed to enact a series of shorthand annotations that would indicate why signatures were either certified or not certified. And there are 4 or 5 different letters that will code into something. But the reason, for example, somebody, an N for not registered, that could mean several things. Could be the individual's not registered. It could mean he's not registered to that address. Could mean that the name is some. There are several different reasons why an N might appear. And it's in my opinion, and I think the opinion of our courts, the obligation of the Board of Registrars to establish why a voter's name is not certified. We struggle, and I think we all admit, we struggle not to disenfranchise our voters. So it seems to me if the petitioners are saying names, and I've heard this said, that there are names which match identically. Whether there are or whether there aren't, I don't know. I haven't looked at it. I'm waiting for somebody to show me. I've heard that there are names where the signatures match, the names match, and the addresses match, and yet they weren't certified. Now, if it's true, I've got an issue with that. That's a problem. But it's not the board's responsibility to show that. It's the petitioner's responsibility. And if the petitioners are going to show it, they're either going to show it here or they're going to show it in Superior Court. Getting into Superior Court isn't a big obstacle. We've already got a case that's pending. If it would have been very instructive for somebody to have gone and presented this to the court, to have the court perhaps give us some direction. The court was certainly willing to give us direction last time. And Attorney Tibbetts smiles because he knows it gave us direction which we ignored, but so be it. But now we have the obligation of being able to substantiate why somebody's name isn't certified. And the only way to do that would be through a challenge by people saying that names were not certified that should have been. That can happen here, it can happen in court. I guess it's up to this board to make that decision, but one thing is sure. It can certainly be done in the court. Can certainly be done in the court. So if this proceeding were to end, it doesn't mean that the recall ends. I think it's a little bit presumptive of us and the media to say that the recall is flopped. This recall is still alive. I'm not sure, if it's clinging to life just temporarily, but I mean, there's still issues to be resolved here. So, I guess if you adopt what Attorney Tibbett recommends, then it make very short business of tonight's meeting. And if you don't, then we need to commence with whatever objections we're going to hear.
I just want to clarify that the McCarthy is the only history that we have to follow.
McCarthy is a case which is somewhat instructive. It is a case which is binding at the state level and the State Ballot Law Commission for nominations. It is, as most of the direction that this board gets on a recall is a form of a citizen-initiated referendum or a petition. It's a particular form. And under our charter, it sets it out in a separate process from a normal citizen-initiated referendum. And that is not what the McCarthy case was about. But if you look at it as an analogy as to how we should behave, it's guidance. But the fact pattern isn't identical. If you want to talk to the Secretary of State's office, they will tell you that this is the case we should follow. They will tell you that. On the other hand, if you look at recent cases, boards of registrars like yourselves are hearing objections from both sides. And I suppose if you were to entertain objections, Attorney Tibbett will run into court and get an injunction to stop us from doing so. And if you don't entertain objections, then Attorney Farrell will run into court and order us to hear them, or order the court to hear them. So either way, they're going to get heard, presumably, if there's a way to hear them. The issue is, who should be responsible for initiating and conducting the hearings? And it shouldn't, anyway.
I would just note in response to your question, McCarthy is not the only case 4,000, and these are written words, 568 registered voters of Worcester versus the city clerk of Worcester is another case. Its citation is 392 Mass. 424, and it's a Supreme Court case that was decided in July of 1984. I've given a copy to...
And you're saying that governs this situation?
Yes, I am.
Okay, hold on,
And it's only 2 pages.
hold on.
What I understood that was said earlier was that it didn't, right?
All right, where in that case are you reading that language, please?
Second page, the very first line, quote, "We noted the legislature did not..."
Hold on.
I'm sorry, page 2.
Well,
That-
have,
too
mine
fast,
is paginated differently than yours. What's the,
Yeah, paragraph, let me see, page, where are we on this thing?
I have
Are you
numbered
Northeast
paragraphs,
second?
1 and 2, 3, 4, 5. Is it?
Okay, 1, let me see, 2, 3, 4. So if you go to paragraph 4, which begins, "This matter is controlled by our decision,"
Yes, go ahead.
okay. There, we announced, and it references McCarthy, there we announced that once a candidate for public office submits in excess of the requisite number of the requisite signatures for inclusion on a ballot, the burden is upon the Secretary of State of the Commonwealth to demonstrate valid reasons for non-certification of signatures. It goes on to say, "We noted that, quote, the legislature did not intend that local registrars be free to reject signatures without giving the reason for such rejection," end quote.
Well, I'm familiar with the case. I have it here. And I agree. The Board of Registrars, in this instance, needs to be able to give reasons why signatures were rejected, not simply the shorthand notation. I've been promoting that for 2 weeks now internally. But it doesn't answer the question, and the question is, in what forum do the registrars have to justify their non-certification? Is the forum going to be here, or is it going to be across the street in the court? And mind you, I again say, there is a pending case, combined case, on both recall petition 1 and 2. And so nobody has to file a new case. All we need to do is produce a motion and bring it before the court for hearing.
Mr. Body, if I may, and I want to, obviously, I address everything to the chair anyway, but I think it's important that the board, and actually, you're a member of the board for these purposes, so I think it's important that you hear and understand this. For the first time, perhaps throughout this entire process, I agree 100% with Mr. Farah. And in fact, the case that he cited said that the matter is controlled by our decision in McCarthy. McCarthy controls. It controls certification of signatures, and it controls this case. What we are saying is that the board has already given reasons through their shorthanded notations, et cetera, in the report that was submitted pursuant to the CMRs. The board, or the city clerk, has already done that, and you've adopted it. So there's nothing in the case that Mr. Farah's provided that suggests anything different than what we've already said. And not only that, this it's an 84 case, but it confirms that McCarthy is still good law.
I know I said I wouldn't refer back to 53, Section 7, applying McCarthy as instructed in this 1984 case. You must review 53, Section 7. And if you can find in 53, Section 7, anything that restricts your ability to decertify or certify signatures, I'd like to see it. It's not there.
Will I be hearing a motion?
Sure. I'm prepared to, I've heard enough, but I'm prepared to proceed with the review of signatures of the petitioners first, because the mayor's side seems to be on the winning side at this point, and that may be determinative as the reason for my motion, but I'll leave it at that. Needs a second.
about seconding your motion. I have to second it?
Can,
No,
Because I'm not clear yet.
My motion-
Can we be repeated?
Please
so I
repeat the
can
motion.
sure. My motion is to proceed with review of the signatures, subject to the objections of the petitioners. First in order.
I don't understand, I'm sorry, I don't understand what that means. So you want to hear both sets of objections?
No, I want to hear the objections. My motion is to hear the objections of, for lack of a better term, the petitions represented by Mr. Farah, first, in order, since they are on the losing side. If they fail to establish their case at the end of our grueling review, then essentially the case may be over. I mean, it seems to make some sense, but I'll leave that to the board if a second is necessary. Which it is, of course.
I can't do it.
I know, but Attorney, can you help? I'd hate to second something I don't quite understand.
What he's saying is,
What I would suggest, if it makes any sense in terms of parliamentary procedure, a second would not secure it. It would be still subject to a vote.
correct,
And it would open it up for further discussion. I think just parliamentary-wise, it's inappropriate to have that discussion now, and I'd be glad to discuss it ad infinitum if you wish, subject to a second.
Okay. I'll second your motion.
And again, if your desire is, I don't mean to put words in your mouth, Registrar, is to compel discussion, that's fine. I mean, that should be taken.
I feel like we've had discussion thus far. I just feel like we didn't end up with what we were deciding to follow, whether McCarthy or, I'm not clear on what the guidelines will be.
I'll further that.
then you understand the issue. Yeah.
That's exactly right.
The reality is that the fact pattern we are presented with has never actually been ruled upon. The closest thing is what Attorney Tibbet has, which is the McCarthy versus Secretary of the Commonwealth case, which by analogy would apply, but understand that, obviously there are distinctions. That was a statewide nomination, I believe it was a presidential nominee, first. Second, that was before there was any standardized procedure, which has now been codified in the Code of Mass Regulations. That was before there was a standardized procedure for reviewing. What was happening in 1976 or before the McCarthy case was that the Board of Registrars in Rowley would certify one way. The Board of Registrars in Fall River would certify another way. The Board of Registrars in Ipswich and Lowell and Lawrence all did it their own way. And there was no standard process. And the court said without a standard process, it's pretty difficult to determine whether the certifications really meet the standard or don't. And so they actually say in the case, we'll leave it up to the legislature. We think this is something that the legislature should address. And guess what? The legislature addresses it. And they create the Code of Mass Regulations that allow us to put the N's and the S's and the T's and whatever the other shorthand annotations are next to the names for certification purposes. And they set forth standards of review. That's why, for example, we had an issue here one time, we were discussing an address that had no street number, it just had the street name. And the standard says that if you just have the street name and no number, even if that person is registered at that street, but if the number's missing, that person doesn't get certified. So they set these standards so that there would be some uniformity from jurisdiction to jurisdiction, so that when the 351 cities and towns of the Commonwealth certify signatures, they're all kind of doing it the same way. So McCarthy, yes, it's still good law, yes, it governs, but there have also been, in the intervening 30 years, changes in the way things are made. Does the change directly affect the review process? No. On the other hand,
How are other boards of registrars doing it? Well, they're hearing both. Are they right in doing so? I don't know. The easiest way to resolve this, perhaps, is to send the parties to the court and have the court give us guidance. But by the same token, we shouldn't shy away from doing our diligence. But that's a vote that the Board of Registrars needs to take. I can't, I'd love to point to something and say, here's the recipe, put in a cup of sugar. It doesn't exist. The closest is what Attorney Tibbet has provided.
If I may, Mr. Chair, and again, just by further explanation, the reasoning behind the motion, the manner in which I presented, is let's get to the nub of this. Let's have and the nub is what Mr. Tibbet basically saying the board, and I don't mean to paraphrase Mr. Tibbet, Attorney Tibbet, the board has no jurisdiction, and I think that's what Mr. Attorney Tibbet is saying. I frankly disagree. I think that this board would be criticized by the court, and if we take steps to address the objections that may change the results of this petition, they exist possibly first in the petitions that are represented by Mr. Farah, and those other turnarounds may occur subsequently in the successful side at this point, the mayor's side. We may very well be hit with an injunction, but it won't be for lack of effort, which has been a criticism of the court and the criticism of at least one of the parties for this board. But I'm prepared on that motion to proceed.
This board is, at a minimum under my tenure, is responsible and accountable for its decision. We reviewed the recall. We made a decision on it. I believe that it is our responsibility to further continue with the process, as boards have before us, as boards have across the Commonwealth. And so for no other reason than to throw down a gauntlet to the court and to come forward and say, no, you've all been wrong. You've been wrong for years. None of you should be putting any signatures back under any circumstances. I'd like to hear that. And so it is interesting that we may, in fact, make some more history. For no other reason, I'd like to continue. And if a disagreement is perfected and the court agrees, so be it. We'll hear that too. I like the motion.
Motion's been called and seconded. Would you call the question, Mr. Chair?
Calling question.
By voice vote at this time, all in favor say aye.
Aye.
Aye. Roll call. And I'll call the roll. Registrar Pereira?
Present?
Yes,
Yes,
President?
yes.
Yes. Myself, William Maloney, City Clerk, voting yes to proceed on the motion as presented. Attorney Body?
Yes.
And Chairman
Yes.
Petrakis. 4-0. We shall proceed, I imagine.
Motion to adjourn.
Motion to adjourn?
I second.
I got 2 seconds. Motion to adjourn, presented by Attorney Body, seconded by Registrar Pereira. All in favor by voice vote, say aye.
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 Roll call. Attorney Body.
Yes.
City Clerk Maloney, yes. Registrar Pereira,
Yes?
yes. Chairman.
Yes.
4-0. This session is adjourned at 6:02.
6:02.